All right, so today we're going to analyze the Duffey versus Workers' Compensation Appeal Board Trollodyne Inc. Incorporated decision. Now, this came out a few weeks ago, just about a month ago, on June 26, 2015. Decision issued by the Commonwealth Court of Pennsylvania. Keep in mind, if you're listening to this recording or watching this recording, at some date in the future, the law may have changed, but at least as of today, which is July 24, 2015, this decision holds. Very important decision. Most of the time when the Commonwealth Court publishes a decision for public consumption, it's an important issue, and they want us to know about it, especially if we're practicing workers' compensation attorneys and employers, third-party administrators, insurance carriers, adjusters, and claimants attorneys. So today, I was just at a hearing today where this very issue came up. I was amazed because I just read this decision and I mentioned it to the judge and he was aware of it. But I have to sort of take a step back and let's look at a few things before we analyze the case. So, an impairment rating. What is an impairment rating evaluation in the Commonwealth of Pennsylvania? A while back, the state legislature amended the Workers' Compensation Act to allow for employers to obtain impairment rating evaluations, much different from or different than independent medical evaluations. In fact, they are totally different animals, in my opinion. An impairment rating can only be requested and obtained. Well, let's take a further step back. What is it? It's an examination. It's a medical examination by a doctor, and the doctor has to be certified to perform an impairment rating, an IRE. All right? It's a section of the Workers' Compensation Act that says you can only obtain it when the claimant is at maximum medical improvement, and you can only obtain it after the claimant has received 104 weeks of benefits. And now that could be all at one time or spread out over 104 weeks, but they have to have 104 weeks. They have to be at maximum medical improvement, and the doctor must be certified by the state and actually take a course and get some training in how to use a big old book called the American Medical Association Guides to Impairment Ratings. I forget the exact title. I'd have to look at it every time I need to memorize that title, but in any event, that's what an impairment rating is. Quite unique because if the claimant's impairment rating is less than 50%, they are only eligible to receive 500 additional weeks of benefits. So it puts an outer limit on the claimant's receipt of wage loss benefits. It does not affect their medical benefits. So having that background, this case, I'll give you the holding. This case, the Commonwealth Court says changing the injury description is not enough to defeat the employer's impairment rating. Simply coming in and saying that the claimant has a different diagnosis or the claimant suffered additional injuries will not stop the impairment rating evaluation train from traveling down the tracks. I just had this come up today at a hearing where I filed an impairment rating petition to modify benefits. My doctor's deposition is scheduled for a couple of weeks away from now in August, and lo and behold, claimant's attorney says to me, oh, the claimant has anxiety and depression, and I'm going to take a psychiatrist's deposition, and I'm going to file a petition to review. And this is all before the hearing, of course, and I just nod my head and said, okay, knowing that is not in and of itself going to be sufficient to defeat my IRE. Interestingly, when we got in front of the judge, the claimant's attorney raised this. I said, Judge, last month, the Commonwealth Court came out with a decision that said simply changing the description of injury does not affect or defeat the impairment rating. Claimant really needs to go and get their own impairment rating from a doctor, and I would say for it to be valid, that doctor has to be certified by the state to perform impairment ratings, must have an active clinical practice, and must follow the AMA guides in order for that impairment rating to be valid. So I said that to the judge, and he agreed with me. He was denying the claimant's request to consolidate the petition to review or add the injuries, the psychiatric injury, with my IRE petition. I objected to it and said, no, I want it to go forward. I'm taking my doctor August 12th. They'll have 90 days to do medical, and then I want the record closed, and the judge agreed with me. But let's look at the facts of the case, because again, these cases take so long to get to the Commonwealth Court level. It's not the fault of the Commonwealth Court. They actually issue their decisions very quickly. Cases take a long time to litigate. So we got a June 26, 2015 injury. Decision. The injury in the case was March of 2009. So the claimant gets injured, both hands picking up some hot wires. They litigate the case. Amazingly, in this case, to the day, almost 104 weeks exactly, the employer requests an IRE. So the employer in this case and their insurance company, their adjuster, their attorney, they know what they're doing. As soon as that two-year anniversary came up, they're requesting an IRE. That's excellent. The IRE is submitted to Dr. Bruce Cecilia. June of 2011, he issues an impairment rating determination face sheet with a report, and he says claimant has a 6% impairment rating. Excellent. He's capped at 500 weeks now. They may have already been in within 60-day window period, so let's explain that. If you request your IRE within a 60-day window of the date that the claimant receives 104 weeks of benefits, the IRE becomes automatic. But let's see what they did here, because that area of the law is a little unsettled. So, the claimant submitted the IRE report to went to the IRE, and he issues the face sheet on June 25, 2011. And the employer issues, for excellent, they know their stuff, they issue a notice of change of workers' compensation disability status form on June 28, 2011, informing claimant that his impairment rating and his disability status changed from total to partial. Now I've got an interesting question here, and I can't find the answer to this. Maybe somebody knows. This is all an automatic procedure now. Because they requested the impairment rating within 60 days of the date that the claimant received 2 years of benefits, and the doctor does his exam and issues this notice of change on June 28, 2011, it becomes automatic. His status changes from total to partial. What happens when a judge issues a decision and approves the IRE? Does the employer still need to issue this notice of change of disability status form? I would. I don't know if you have to or not, because a judge is issuing a decision. I've never seen a case on that issue yet. But in any event, the change does not reduce the claimant's benefits, but it limits his receipt to 500 weeks. All right, that's important. So when you have an impairment rating that is less than 50% and the notice of change is sent out, changing the status from total to partial, he's limited to 500 weeks because it's a partial claim now. All right, it doesn't change the amount of money the claimant receives each week. It simply changes the outer limit, the final date that the claimant can actually get benefits. It puts a cap of 500 weeks on his receipt of benefits. So what happens then? Claimant files a, excuse me one second, I'm sorry about that. It flipped over to deal. Let's go back. Claimant filed a petition to review, asserting the IRE was invalid. Petition to review doesn't allege how it's invalid. Claimant later asserted that the IRE was invalid because the description was incomplete. Oh, okay, so interesting. Doesn't go out and get their own impairment rating, which is what the statute says they're supposed to do. You're supposed to go and get your own impairment rating if you're challenging the impairment rating that's established. Claimant testifies, parties submitted their respective physicians' depositions. So, interesting, so the employer must have taken a deposition to either challenge the, I hope they didn't try to challenge the IRE with another medical deposition. I would imagine they challenged the description of injury. And let's take a step back. You know, a lot of times things need to be explained over and over again in workers' comp because we're building on each case. Description of injury is so important in a workers' compensation case now. It has been for the last 10 years, but even more so now. At every stage in a workers' comp case, you must know what the accepted work-related injury is. If it's the NCP, and that's the controlling document, and you have no other WCJ decisions, judges' decisions, or stipulations that have been approved by a judge, the NCP injury description is what controls. If you then have a claim petition and a judge writes a decision and adds herniated disc or carpal tunnel syndrome to the previous low back strain or wrist strain and sprain, that becomes the controlling injury, the controlling description of injury. Each step of the process you have to know that, because every time your doctor testifies, he or she better know what the accepted injury in the case is. And he or she better not disagree with the prior judge's decision. Because if the doctor does that and says, I disagree with Judge so-and-so, the judge said there was a herniated disc, I don't see a herniated disc, there never was a herniated disc, this claimant had a lumbar strain and sprain, my opinion is he's fully recovered. Not only are you going to lose that termination petition, or whatever petition you filed, the judge in all likelihood has a good basis to hit you with a penalty and an unreasonable contest attorney's fee, because you've now litigated a case where the doctor, the opinion of that doctor is invalid as a matter of law. They've got to agree with the accepted injury. They can say they're fully recovered from the herniated disc, and that's okay, but they can't change or disagree with what has already been established in the case. That's why we're fighting so much about, and that's why in this case, claimant's now trying to change the injury to something else to then argue that the IRE is invalid. And I'll show you why that's not going to work. So, claimant takes Dr. Bell. She diagnoses claimant with an adjustment disorder and a depressed mood. Let's see who else. Employer takes the guy who did the IRE, which is good, and Timothy Michaels. The IRE doctor testified that there was a 6% impairment rating, and it addressed only those injuries described as work-related in the designation sheet and did not review claimant's mental conditions, nor should he have. That's not part of the case. So the IRE doctor is not under no obligation to analyze every single claim or injury that the claimant might be dreaming up at the time of the IRE, unless it's an accepted injury, unless it's in an NCP or a judge's decision, or a supplemental agreement, or a stipulation of facts. That doctor has not only does the doctor not have an obligation to look at those injuries, I would argue, he or she is precluded from looking at those injuries under the way the IREs are supposed to be done. So, Dr. Michaels, interesting, a board-certified forensic psychologist, acknowledged the claimant suffered from an adjustment disorder, but opined that he was fully recovered and disagreed with Dr. Bell's diagnosis. Okay, I wouldn't even put Michaels on to say fully recovered from that, because by saying they're fully recovered, you're sort of agreeing that's work-related, I would think, unless there was no causation. But in any event, the judge accepts claimant's testimony. Claimant had established that he suffered additional work injuries. The WCJ concluded that the IRE was invalid because it did not address claimant's additional work injuries. That's a killer. Because, when the Dr. Cecilia did the IRE, at the time of that IRE, the mental claim was not an accepted work-related injury. So how can the doctor look at that? And of course, he can't go back in time and change the IRE report. So he grants the review petition and changes the disability status. Employer appeals to the board. The board held that the IRE was valid because although Dr. Bell's notes indicated a diagnosis, claimant never sought to amend the NCP to include the diagnosis until long after the IRE. Thank you, appeal board. Of course that's true. How could the IRE doctor, does the IRE doctor have to do Karnak the Magnificent and predict that the claimant's going to allege at some point down the road that the mental injury is work-related and litigate that whole claim? That's ridiculous to require an IRE doctor to do. The judge was completely wrong in this case, my opinion. Completely wrong. And it's proven by the appeal board decision and the Commonwealth Court opinion. I don't know who the judge is. Judge isn't identified. In any event, claimant never sought to amend the IRE, the NCP. The judge accepted the doctor's testimony that the IRE was at MMI, and his determination wasn't refuted by claimant. So they never argue about MMI in this case. And, that's a waste of time, too, based on all the Commonwealth Court decisions I've seen, with rare exception. Claimant arguing that they're not at MMI 2 years after a work injury simply isn't going to really hold any water under the way that the American Medical Association defines MMI, maximum medical improvement, in the American Medical Association guide on impairment ratings. So in any event, they go up to the appeal. Claimant appeals. They look at section 306A.2 of the Act. And that says once the employee gets to 104 weeks, receives 2 years of comp, unless otherwise agreed to, they are required to submit to an impairment rating within 60 days. Impairment is different than injury. It's different than disability. Impairment is not disability. Two different concepts. I wish the claimant bar would figure that out. Impairment, does not mean disability. Disability does not mean impairment. Impairment is defined as an anatomic or functional abnormality or loss that results from the compensable injury and is reasonably presumed to be permanent. That's what an impairment is. Which is interesting, because there's other cases that say we can still get a full recovery even though under the Act impairment is presumed to be permanent. Doesn't mean it is permanent, it's just presumed. If the claimant's found to have an impairment equal to or greater than 50%, he's totally disabled and continues to receive total disability benefits. If the impairment is less than 50%, claimant's status changes to one of partial. And then it says no reduction shall be made until 60 days notice of modification is given. Okay, so claimant has a right to immediately appeal the reduction of his or her disability status before the reduction becomes effective during the 60-day notice period. So, yeah, that's important because there's been some litigation on that. So once the claimant gets that notice of change of status from permanent to total, from total to partial, excuse me, they got 60 days to file a petition review. During this period, the claimant can challenge the IRE itself. Claimant's not foreclosed from subsequently challenging the reduction if an appeal is not filed during the 60-day period. Section 306A.24 provides a claimant may appeal the change at any time during the 500 weeks if there's a determination that the claimant meets the threshold impairment rating that is equal to or greater than 50%. Once again, I say this a lot in workers' compensation. Read the statute. A couple lawyers I know, they carry a copy of the statute with them to every hearing. I don't do that, but I probably should. But read the statute. If you want to challenge a previous impairment rating and you're the claimant, you need to do that by way of getting a determination that the claimant meets the threshold rating that is equal to or greater than 50%. Right there they tell you. In other words, after the 60-day appeal period has passed, but before 500 weeks, a claimant may attempt to reinstate total disability status by presenting an IRE showing an impairment rating equal to or greater than 50%. You don't do it by filing a petition to review to add or change injuries. Arguably, now I have another case where I'm arguing that you can't even challenge the IRE simply by making an argument that the claimant is not at MMI and having your doctor testify claimant is not at MMI, therefore the IRE is invalid. I don't even think that's sufficient, in my opinion. I think anytime a claimant wants to challenge an impairment rating, the claimant must go get another IRE and pay for it and have a doctor testify that you're not at MMI and therefore you don't satisfy the requirements of the American Medical Association guides to impairment rating under the statute. But I see that a lot, and I just argued it in the case the judge really didn't look at my argument. He simply said my doctor was more credible and therefore the IRE was granted. But I made the argument that if you look at the statute very closely, the only way to challenge an IRE under the statute is to go get your own IRE. But we'll see if the court goes that far. I think if they're saying here in the Duffey decision that changing the description of injury isn't enough to defeat an IRE, then why would having your doctor testify that the claimant is not at MMI be sufficient? That's not sufficient either, in my opinion. I think you got to go get an IRE. So they cite the arguments of both sides. You can go in and look at all that. It's not really that interesting. The employer was right. They said, well, this is what the statute says. They analyze it. The court analyzes Section 511.2. Defines impairment. It is well settled that the NCP that establishes that it is the NCP that establishes the description of injury. Section 306 directs the IRE physician to base his impairment opinion on the injury described in the NCP. Now, it's not that limited. It's also whatever the judge may have amended the NCP to include. It is the claimant's physical condition at the time of the IRE that governs the validity of the IRE. So if you look at a timeline, go from here to here, and that's your timeline. When the IRE is done is what the doctor looks at the claimant's condition at that time. We can't predict 2 years from now if the claimant's going to add a mental injury, that was a part of the work-related injury. It doesn't work that way. It's all on a timeline. The IRE produces a snapshot of the claimant's condition at the time of the IRE, not a survey of the claimant's work-related injuries over a period of time. And at that snapshot, you have to look at what's the accepted injury, what's on the NCP, what did the judge in the previous decision rule was work-related. Pursuant to the statutory language and the precedent, the focus in determining the validity of the IRE is on the state of the claimant and the compensable injury as described in the NCP at the time the IRE is performed. So, more analysis. They say Wingrove is distinguishable. I can't recall Wingrove. It was a long time ago. So let's see what Wingrove said. Employer asserts that this court's recent decision in Wingrove, supports the board's conclusions. However, Wingrove's distinguishable. So what happens in Wingrove? Claimant's disability status was changed from total to partial based on an impairment rating of 11% in 2005. 2009, 4 years after the IRE, the claimant filed 2 review petitions seeking to modify the description of injury in the claimant's NCP to include additional injuries and challenging the IRE because it did not take into consideration the alleged injuries claimant sought. So once again, I'll call this a backdoor. They're trying to backdoor the IRE. They wait 4 years and say, hey, 4 years ago, when that IRE was done, it didn't include all the injuries, therefore it's invalid, Judge. We want you to throw that out. Come on, Judge. You can do it. Following the hearings, WCJ granted one of the review petitions and added several injuries to the NCP. Regarding the IRE, however, the judge said the expansion of the claimant's work injuries did not negate the validity of the IRE in 2005. Thank you, Judge. That's correct. The board affirmed on appeal to this court. We affirmed in doing so. We held that once 60 days has passed, the IRE became fixed and beyond challenge. Pursuant to section 306A2.4, 8.24, the burden shifted to the claimant to prove that the addition of depression rendered him 50% impaired. Because the claimant did not prove this, the claimant could not have his disability status reinstated to total. Thus, in Wingrove, the claimant could not attack the IRE because it was not filed within the 60-day immediate appeal period. Here, by contrast, claimant's appeal was filed within the 60 days. Okay, so they say Wingrove is distinguishable because in Wingrove it was more than 60 days after the IRE notice changing the claimant's status from partial to total. Yeah, that's true. I mean, the concept is the same, I think. I think the concept is all the same. The Wingrove concept and the Wingrove philosophy is that it's at the time the IRE is done. And again, filing review petitions isn't going to change it. But anyway, they distinguish Wingrove. They want Wingrove to stand on its own. But then they say our conclusion that Wingrove is distinguishable does not require us to conclude that the IRE was invalid because it didn't address the injuries that were found to be work-related after the IRE was performed. Yeah, I think they go hand in hand, quite honestly. Given the language of Section 306 and the goals of the 1996 amendments, and by the way, 1996 was when the statute was amended to include this IRE provision. We do not believe that the General Assembly intended to nullify an already performed and otherwise valid IRE by claims of new or additional injuries that were not yet determined to be work-related. The special IRE procedure was part of the General Assembly's 1996 reform effort intended to reduce rising workers' compensation costs and to restore efficiency to the workers' compensation system. It would not improve the efficiency of the system. So what do they say you got to do? Our conclusion does not foreclose claimants from challenging the change to partial status if additional injuries are recognized or adjudicated as being work-related. Pursuant to Section 306, a claimant can challenge his or her partial disability at any time during the 500-week period of partial disability if he obtains an impairment rating of at least 50% using the AMA guides. Let's read that again. He can challenge it if he obtains an impairment rating of at least 50%. He must obtain an impairment rating of 50% using the AMA guides. Weekly benefit stays the same, and he's subject to 500 weeks. Interesting. So I see a trend. I won't even call it a trend. I see an absolute, with rare exception, sustaining of impairment ratings by the Commonwealth Court in almost every workers' compensation decision that's in front of them. They do not want to throw the impairment ratings out. They are finding ways to make certain that the impairment ratings always hold and stick. Not to say claimant can't challenge it, but claimant's going to have to go and get his or her own IRE that is greater than 50%, something that's difficult to do. That can be done. It probably, in my opinion, should be done when the initial IRE is being litigated. If a claimant's going to challenge an IRE, they should go and get their own IRE and challenge the employer's IRE with their own IRE. I'm not seeing that happening though much, probably because it's a cost that's involved. Once again, thanks for listening. Interesting case. I'll put this up online. If anyone has any questions, please feel free to contact us at any time.